Mr. Speaker, I thank the members who have spoken on the bill, as well as for their support, by and large, for the amendments. There are some clarifications or queries that have been raised, and I would like to address them. Let me deal first with video recording of interviews. Mr. Patrick Tay asked how police officers are being trained to take video recorded statements. Mr. Desmond Chu made a similar comment, whilst also suggesting training for court officers. The police have a training program in place for taking statements while on camera. They go through a 4-day course, which include interview skills, administrative procedures in conducting a video interview, and how to tackle equipment failure. This is vital for consistency in the way video interviews are conducted. Sufficient officers have been trained to implement Phase 1. As mentioned, the need to train officers in the skills and techniques needed to take video recorded statements is one reason why VRI is being rolled out in phases. The police will fine-tune the training program as they gain experience from the use of VRIs in Phase 1. As for the other users of the system, such as court officers, we will be engaging the relevant agencies to ensure that everyone is familiar with the new scheme before the first cases involving VRI enter the system. Mr. Tay also asked about safeguards put in place to ensure that the security of video recorded statements is not compromised. There will be safeguards in place to minimize the risk of loss of disks containing video recorded statements, and viewing of the video recorded statements by the Defense Counsel will only be allowed at designated locations where recording devices will not be allowed. Mr. Madhav Mohan asked about copies of the videos and why they're not given to this Defense Counsel and how many times the defense will be able to view them. The copies of the video recorded interviews will not be handed over to the Defense Counsel, as video recorded interviews may be leaked, they may be lost, misplaced. So this is really to make sure that there's a safeguard against the video recordings being misused. However, instead of handing over a copy of the video recorded interview, Defense Counsel will be able to view the recording at an approved place any number of times. A copy of the transcript of the recording will also be extended to the defense during the CCDC process. And it was felt that an undertaking would not be sufficient for this purpose because, for example, there's some people who are unrepresented, and an undertaking by an unrepresented accused person with no professional responsibilities may have a limited deterrent effect. And if the worst happens, and if, let's say, the video is leaked for some reason, punishing the lawyer or party responsible will not reverse the harm. In terms of, oh yes, and there's also what the consequences of what happens if the video is distributed on the internet, because the impact is widespread. With VRI of victims, are leading questions allowed? The answer is that investigators should not be barred from asking leading questions because they're not legally trained, and the procedural rules should not be introduced at this investigations stage, where really the aim is to find out what happened, and the judge can view the recording and come to his or her own conclusions about reliability. Mr. Kok Heng Leun was concerned that there should be sufficient safeguards to ensure the integrity of the video recorded statements. Much of the infrastructure is modeled on the best practices in other jurisdictions which are experienced in the use of VRI. The technology adopted is also consistent with best practices to minimize litigation on the authenticity of the video statements. So, for example, the rooms for VRI are purpose-built to ensure video statements of good quality, both for sound and picture, while ensuring that other operations are not compromised. These have been modeled on the purpose-built rooms used in Hong Kong for VRI. Mr. Louis Ng asked whether the government would consider the use of video recording in the preliminary interviews or other exchanges prior to the statement recording. On a related note, Mr. Kok expressed concerns about interactions between the police and the suspect outside of the interview. There would be various conversations between the police and the accused persons from the time of arrest until statement taking, and it will not be possible for officers not to have any conversations throughout. However, it would not be feasible to record every exchange that officers have with the accused person, and really the primary intent of the interview is to take that person's statement. So the video recording will form the basis of the statement. Mr. Ng also asked whether the government would consider requiring the video footage to show both the suspect and statement taker, as well as the full extent of the space in the room. And Mr. Kok expressed a similar concern on capturing the suspect's demeanor accurately. There will be 2 cameras mounted in the room, one of which focuses on the interviewee, and the other captures an overview of the entire room. By way of a convex mirror installed in the room, the full extent of the room can be observed in the camera. The default angle to be used in court, if any, would be the view focused on the interviewee so that the demeanor of the interviewee may be seen in detail. The overview may be shown as well, if so directed by the court, for instance, to verify the accuracy of sign language interpretation. Finally, Mr. Ng asked whether the government would consider making video recordings mandatory for all offences punishable with death or life imprisonment, and for all vulnerable suspects, including juveniles, the elderly, the cognitively impaired, or the psychologically disordered, regardless of the alleged offence. We're not closed to the idea of extending VRI further to more offences and to vulnerable suspects. However, VRI is a complex initiative. Infrastructure needs to be put in place, as I've mentioned, the purpose-built VRI rooms, and even specially designed tables so that the persons in the room cannot be obstructed from being seen on camera. Investigating officers need to be trained as the entire statement-taking methodology changes, because there will no longer be any written statement if a VRI is to be recorded. It's therefore necessary that implementation will be done in phases to iron out whatever issues may become apparent and to ensure that there are adequate resources. We'll consider this feedback as we expand the use of VRI in future phases. Ms. Sylvia Lim asked for clarification on the circumstances that a police officer will take into account in deciding that a video recorded statement should be taken in cases where it is not mandatory to do so. In deciding to exercise any power of investigation in the law, all criminal investigators generally consider the same factors, and the ultimate aim is to advance the investigation, meaning to discover whether any criminal offence has been committed and the full facts of that offence, including those who committed it. So in this context, it's not possible for me to give an exhaustive list, but it would be a situation, I would assume, where the value of a video recording would be high. So for example, if you have an accused with a mental disability, for example, when you record a statement and you see the transcript, the way the answers come out may make a lot of sense, but when you look at the person, the facial expression, the way somebody who is mentally disabled or have some cognitive disability is responding, that tells you another picture. So that is an example of the sort of scenario where the investigator might decide in this particular instance, before we roll out other phases, to do so. Let me now respond to questions on video recorded statements of victims, which will only be implemented in later phases after we have further studied the operational issues. Mr. Christopher D'Souza asked for a clarification of how we will operationalize the video recording of statements from victims. While the operational details are yet to be worked out, we expect that specially trained police officers will take the video recorded statements from such victims. We will consider whether to require the recording officer to inform the victim from the outset that the statement would be used in a court proceedings when we develop the details of implementation in consultation with stakeholders. Mr. Kok Hin Lun asked about the timeline for implementation for video recording of statements from victims. There is a need to allow the law enforcement agencies sufficient time to train the investigation officers, to study the lessons of the pilot, and then to prepare the necessary facilities for VRI of victims. The prosecution, members of the criminal bar, and the judiciary will also require time to acclimatize to the use of VRI evidence in court. So as Mr. Kok has pointed out, there are complexities involved in video recording of statements from victims. So we'll therefore carefully monitor the first phase of VRI implementation before deciding how to operationalize video recording of statements from victims. Mr. Tay asked whether there'll be a set of guidelines to assist police officers. The police will develop their internal guidelines on this. As mentioned, the use of video recorded statements for victims will only be implemented in later phases because of the complex issues I have highlighted. Ms. Joan Pereira asked whether victims will be given a choice of whether to give a statement via video or in writing, and Mr. Kok asked a similar question. Investigators will make a decision on the mode of taking the statement. However, the victim's willingness or level of comfort with giving a video recorded statement will be an important factor. So we'll work again with the stakeholders to decide how best to operationalize this sensitively before implementing it in future phases. Ms. Pereira asked what measures will be taken to ensure that victims are not disadvantaged if they're unable to recount the alleged incident because he or she is traumatized. Victims can indicate their preference not to give their statements on video if they are uncomfortable with it. The victim's preference and his or her composure or state of mind at the time of statement taking will be taken into account by the investigator in deciding on the appropriate mode of recording. And for sexual crime victims, their cases are handled by specialist investigation officers who are trained in victim care. Mr. Tay asked a question, not exactly in relation to VRI, but related, whether we should review the rule which allows for a statement made to a police officer ranked sergeant or above to be admitted in evidence. While there may be more officers, including newer officers, who hold at least the rank of sergeant today than before, it would be mistaken to take that as a lowering of the standards expected of officers of that rank. The police have rigorous training programs and internal guidelines in place to ensure that anyone with the rank and authority to take statements does so with the highest level of competence and professionalism. Next, I move on to the computer-related powers of investigation. Mr. Desmond Chu supported the enhanced powers, but expressed the hope that they would be exercised with care. I would like to assure the member that these powers exist only to facilitate criminal investigations. The police will take into account the nature of the cases and the requirement for the information before issuing any order under Section 39. Mr. Louis Ng asked for clarification of the rationale behind the amendment which allows a male officer to search a woman suspected of a terrorist act and what safeguards there are to ensure that searches are made with strict regard to decency. There is a well-recorded history of the use of women in terror attacks. Some have been coerced into this role, but others have volunteered. Between 1985 and 2008, female suicide bombers carried out more than 230 attacks, about a quarter of all such acts. One of the earliest users of this tactic was the Liberation Tigers of Tamil Eelam, LTTE, or the Tamil Tigers, in their campaign against the Sri Lankan government. They assassinated former Indian Prime Minister Rajiv Gandhi in a suicide bomb attack in 1991. The attacker was a 17-year-old girl. Tragically, this is not a phenomenon of the past. The BBC very recently reported that Boko Haram in Nigeria has been kidnapping girls, some as young as 13, and forcing them to go on suicide bombing missions in crowded public areas. This was confirmed by some girls who managed to escape. Female suicide bombers deployed by Boko Haram have killed more than 1,225 people. Research suggests that terror groups use female attackers to gain specific tactical advantages. These include a perceived unwillingness on the part of security officers to search women. In Iraq, Al-Qaeda repeatedly exploited a cultural taboo against the searching of women, allowing their female suicide bombers to pass through checkpoints without being searched. So, it really is about striking a balance. In our case, as mentioned, male officers will only be allowed to search a woman in very narrowly defined circumstances. First, the officer must reasonably suspect that the woman is involved or has involvement in a terrorist act. Second, the officer must believe in good faith that the terrorist act is imminent. Third, the officer must believe in good faith that the search cannot be made within a reasonable time by a relevant officer who who is a woman. The rationale, as explained, is that time is of the essence in such situations, and it's where any delay could mean a loss of lives. The police will put in place strict standard operating procedures to ensure that the searches are made with strict regard to decency. Now, bail. Mr. Christopher D'Souza asked whether the prohibition against indemnity agreements would make it unduly difficult for families to raise bail monies, as they sometimes need to get contributions from relatives and friends. The prohibition against indemnity agreements is premised on the seriousness of a surety's duty. The serious nature of this duty has been emphasized by the court on various occasions. For example, the High Court reiterated in a case last year that surety's obligations were of cardinal importance and consequences of significant gravity must therefore attach to any breach of such obligations. It is therefore important that we don't allow sureties to be indemnified by third parties, as doing so would remove the incentive for them to fulfill their obligations. Having said that, I should clarify the scope of the offense. It will require that the surety enters into agreement with the third party that if bail is forfeited because the accused person absconds, the third party will cover all or part of the forfeited bail that the surety will be liable to pay. It does not mean that the surety can never borrow money to raise bail. For example, if the surety borrows some money to raise bail and remains liable to repay that money, then it's not an indemnity. In other words, the surety must have a vested interest in ensuring that the person turns up for court. Mr. Patrick Tay asked for statistics on the frequency of bail granted and the incidence of absconding in the past 5 years. He also asked whether such persons were later apprehended and how they were dealt with. Criminal practitioners will know that bail is granted in the vast majority of cases. Notwithstanding the recent high-profile case, absconding from bail is also rare. When accused persons on bail abscond, the bail sum pledged by the surety may be forfeited. If the accused person is still within Singapore, attempts will be made to locate and arrest them. In the event that the accused person flees overseas, police may issue an Interpol red notice. Police forces in Interpol member states will then help to locate and arrest the accused person. The wanted person may then be extradited back to Singapore. Absconding from bail is also an aggravating factor which could result in a higher sentence when the accused person is later brought back to face charges against him. The changes made to the CPC in this bill will further strengthen our bail regime, and in particular, absconding from bail will be made an offence. Mr. Tay also asked about the rationale behind allowing bail for extradition cases where special circumstances apply and what such special circumstances would be required to grant bail in such cases. We thought it would be too harsh to prohibit bail in extradition proceedings without exception. The specific special circumstances which would justify the grant of bail will be prescribed in subsidiary legislation. So, for example, special circumstances could exist if the accused person was a juvenile or was sick or infirm. I'll move on now to enhancing protection for victims of sexual and child abuse. I'm very heartened that so many members have stood up to support the proposals on enhancing protection for victims of sexual and child abuse. Mr. Kok Heng Leun related a particularly moving story about the impact on a victim, and many of the other members too have cited examples. And this just goes to show how much impact court procedures can have on a victim and how they can sometimes be forced to relive over and over and over again the dreadful experience that they first underwent. So it is very important that we have to address this. Mr. Tay had pointed out some myths and stereotypes which may be associated with sexual offences, and while not all of them can be addressed through legislation, the present amendments do go some way towards tackling them. So Mr. Tay asked about sections 366 and 367 of the Penal Code and whether these could be included in the first schedule of the Evidence Act. The first schedule currently lists the main sexual and child abuse offences that are more frequently prosecuted. Sections 366 and 367 of the Penal Code are offences of kidnapping or abduction, albeit with a sexual element. Prosecutions under these provisions are rare. That said, the first schedule gives us the flexibility of including other offences where it is determined that restrictions should similarly apply. Mr. Tay also asked whether more offences, such as those for criminal intimidation or harassment, should be given the same treatment. In particular, he's concerned about instances where the criminal intimidation imputes unchastity to a woman or where harassment is sexual in nature. He asked whether the judge ought to be given the flexibility to decide to apply similar restrictions on cross-examination, even though they're not offences listed in the first schedule. The restrictions on cross-examination are intended to apply to those sexual offences where questions relating to the victim's sexual behavior, sexual history, and the physical appearance are most likely to be asked. For other offences, such as criminal intimidation or harassment, the Evidence Act gives the judge the power to disallow certain forms of cross-examination. So as a starting point, only relevant questions can be asked on cross-examination, and the court has the power to disallow questions that are intended to insult or annoy. Indecent and scandalous questions may also be forbidden. Mr. Madhav Mohan asked whether the restrictions would create a chilling effect on defense counsel, which would make their difficult job even harder. The answer is that actually all that is required is for leave to be sought in advance. So long as the counsel can show that it is relevant and that there is a good reason for it, leave should be granted. And leave will be granted if it's in the interests of justice. So we're not saying that the topic cannot be raised, but you must show a very good reason why you are asking those questions. Finally, Mr. Tay suggested that there should be a set of guidelines on the use of screens in courtrooms. We're aware of the various operational issues that may arise, and we will work closely with stakeholders on implementation to ensure that the use of the screen is not counterproductive. Mr. Louis Ng had asked whether the government will also consider enhancing penalties or creating new offences, especially for online predators. The government has announced this before, and I'll emphasize, there is a Penal Code Review Committee that has been set up to conduct a broad review of the Penal Code. The area of sexual offences is one area that we are looking at. The committee will complete its work and make its recommendations sometime this year. These recommendations will include recommendations on whether penalties should be enhanced and whether new offences are needed. Mr. Ng also sought a clarification on what questions the proposed Section 154A(1)A of the Evidence Act will cover that do not already fall under the scope of Section 154 today. On a related note, Mr. Ng asked whether the combined effect of the new Section 154(1)A and Section 154(2)C is intended to stop certain questions even before they are asked. The specific restrictions will be set out in subsidiary legislation. As explained, the accused or his counsel will not be allowed to ask questions about the victim's sexual behavior with persons other than the accused when such behavior does not relate to the charge, unless leave of court is first obtained. Hence, unlike Section 154, which is broadly phrased in terms of questions that are forbidden, Section 154A will be more specific. As Mr. Ng has pointed out, the requirement for prior leave is also a key difference between Section 154 and Section 154A. This will ensure that only appropriate questions that are in the interest of justice may be asked. The leave stage will also insulate victims from hearing insulting and irrelevant questions, as the court will not permit such questions to be asked. Finally, Mr. Ng also asked a very specific question on whether offences under Section 356, which are of a non-sexual nature, will be caught under the definition of sexual offences in the new Section 154A. Ms. Joan Pereira asked Yes, that's right. Sorry. The restrictions will only apply if the accused or defense seek to ask questions relating to the victim's sexual behavior. If these types of questions are asked in the context of an offense under Section 356, then the restrictions may apply. Section 356 has been included because victims of such offences have always received the benefit of certain protective measures, such as being able to give evidence via video link. To have them taken out would also mean that a class of victims that were previously given the benefit of protective measures would now be deprived of the new protections. However, even after this legislation, we will continue to review the classes of victims that will be covered by various protective measures to ensure that the correct balance is struck. Ms. Joan Pereira asked what recourse a victim has if she felt that a counsel had ridiculed her to the point of disparaging her reputation during a court hearing, and whether the presiding judge would consciously be on the lookout for irrelevant, insulting questions. As we've seen in previous cases, lawyers who cross the line may be subject to disciplinary proceedings. Judges are also vigilant to ensure that questioning by defense counsel does not cross the line. The measures that we're putting in place today will further strengthen these safeguards by allowing the minister to make rules to further restrict the kinds of questions that be asked of alleged victims during cross-examination, including the introduction of a requirement to ask the court's permission before certain questions are asked. The fact that the court can control the questions before they are asked in the absence of the victim is significant. This gives the judges more control over the proceedings to ensure that the victims are not intimidated by insulting and irrelevant lines of questioning. Ms. Pereira also mentioned that it's important for investigators to handle DNA samples and other forensic evidence carefully. I would like to assure Ms. Pereira that our investigators are held to rigorous standards. And should any mishap occur, which hopefully they will not, the relevant agencies will conduct internal investigations and make improvements to their protocols where needed. I move on now to the enhancement and rationalization of fitness to plead in the unsoundness of mind regime. Dr. Tan Wu Ming asked what would happen if the maximum term of confinement under the CPC has been reached and the subject is still found to be unsafe for discharge as he or she remains a danger to himself or herself or others. He or she will be transited to the regime under the Mental Health Care and Treatment Act and will continue to be confined for treatment, usually at IMH. So it's just that the criminal charge element is removed. A person confined under the Mental Health Care and Treatment Act is periodically reviewed and assessed for his or her suitability for release. I move on now to the deferred prosecution agreements. Mr. Christopher D'Souza asked whether the requirement for corporate offenders to be represented by counsel includes in-house counsel. The legislation states that the party must be represented by an advocate, which is defined as an advocate and solicitor lawfully entitled to practice criminal law in Singapore. Having said that, in-house counsel who do not fall into this category can assist or participate in negotiations on the DPA. But obviously, when you go to court, you'll have to be somebody who has the rights of audience. Mr. Patrick Tay asked whether a code of practice for the use of DPAs, similar to that published in the UK, will be published here. The answer is no, because that would be similar to publishing prosecutorial guidelines, and we have a slightly different approach from that of the UK. The publication of the Code of Practice in the UK is consistent with their general position that prosecutorial guidelines are published. In Singapore, the general position on such publication is different. This is to ensure that prosecutorial guidelines do not become a tool for criminals to refer to in manipulating the criminal justice system to escape punishment. Mr. Murali Pillay asked for confirmation that the legislative framework on DPAs does not preclude the court from allowing interested stakeholders to join in the proceedings. We can consider this issue further. However, the basic position should be that a company's decision-making power lies with its board. Other stakeholders, such as shareholders, do not have the same power, and the courts have actually pronounced on the reason for this. The reason is that the board and the directors have a fiduciary duty. They are obliged to act in the best interest of the company. Shareholders do not have a similar fiduciary duty. Shareholders are free to act in their own interests. So in some cases, the interests may well be aligned, but sometimes they may not be. So at the end of the day, really, when you're entering into a DPA and negotiating with it, the primary decision-making power should rest with the company and its board. if the shareholders have issues with the decisions, then they have other avenues available to them, such as the general meeting and, of course, the other rights available to shareholders under the Companies Act. It is open to the court to ask for information about the possible impact of a DPA on various stakeholders to assist in making its decision on the approval of a DPA. Mr. Murali also proposed that monitors appointed under a DPA be subject to oversight by the court. The conditions that can be attached to a DPA are deliberately left flexible, subject to the High Court's approval. So it's open to parties to negotiate and set out details concerning the role and supervision of monitors in the DPA. Mr. Patrick Tay and Mr. Vikram Nair and Ms. Sylvia Lim asked about why the High Court is not required to give reasons in a DPA decision, and Ms. Lim also asked why DPA proceedings in the High Court would be held in camera. Let me take Ms. Lim's question on the in-camera hearings first. We considered that if DPA approval proceedings was held in the public view, and if the DPA did not eventually come into force, the company negotiating the DPA would be prejudiced or could be prejudiced in any future criminal proceedings based on the same facts. That was actually the point that Mr. Murali Pillai made, because if companies have reason to fear that their willingness to negotiate a DPA will prejudice their defense later on, then they may be unwilling to volunteer information or cooperate, and the benefits of the DPA scheme will then be undermined. And that's the same reason that representations written by the defense to AGC are protected by the without prejudice privilege. So it's essentially the same underlying philosophy that applies to without prejudice negotiations. The same reason explains, well, with respect to the other question of why we do not require the courts to give reasons, some of it relates to this, but the general thinking is this. The DPA is not a judgment. So it doesn't have a binding effect, it's not stare decisis, it doesn't set a precedent for other DPAs. Every situation will be highly fact-specific. And the approval will only be granted if the DPA is in the interests of justice and its terms are fair, reasonable, and proportionate. So that's the first threshold. The court should not obviously grant or approve the DPA unless it has met that threshold. Now, under these rules, the court is not prevented from giving grounds. So, in other words, the system that we have is actually consistent with the current system that we have for any other type of judgment, whether it be criminal or civil, meaning that our courts are not sort of under a compulsory obligation to publish grounds, certainly at first instance. If it goes on appeal, it's different, because obviously in appeal, you're looking at the reasons why the judge decided in a particular way, and you need the grounds for decision. So currently, for criminal and civil proceedings, courts sometimes give grounds, they sometimes give oral grounds, sometimes they give written grounds. So it's the same for this. It is open to the court to give grounds if the court wishes to do so, but there will also be some cases which are actually very straightforward, and it's not necessary for the court to give written grounds. So we essentially leave it to the courts, and the courts can decide where it may be appropriate to do so. I am aware, of course, that in the UK they give grounds, but there are other jurisdictions where DPA is applicable where they don't, such as the US, for example. So we thought that we would just have a system that is consistent with the current practice on judgments. Moving on to the Criminal Procedure Rules Committee, Mr. Tay proposed that the CPRC should seek inputs from social science and technology experts. The CPRC will consult the relevant stakeholders where appropriate. On abolition of committal hearings, Mr. Vikram Nair asked for an assurance that with the replacement of committal hearings with the transmission procedure, there would still be sufficient safeguards to filter out unmeritorious prosecutions. As mentioned, the key benefit of committal hearings, as practiced today, is pre-trial documentary disclosure of the prosecution's case. Today's amendments extend the pre-trial disclosure regime to cover practically every criminal offence that is likely to be tried at the High Court. At trial, the defense is free to cross-examine the prosecution's witnesses. If at the end of the prosecution's case there is no prima facie evidence of guilt, the accused will be acquitted without being called upon to raise a defense. This threshold, together with the criminal case disclosure process, provides the answer to Mr. Nair's question. And this move will actually benefit accused persons in reducing their time spent in remand or waiting for the trial to commence, as well as the overall administration of justice. So in short, basically, the committal hearing procedure before had two main advantages. One is the disclosure or discovery, and second is the cross-examination. What the statistics have shown is that the cross-examination part of it is very rarely invoked, but we will, of course, keep the discovery part. And you still get a chance to cross-examine when it goes up to High Court trial, and the benefit is that you shorten the time the person spends in remand. I move on now to the video link hearings. Mr. Desmond Chu asked what safeguards there will be to ensure that the usage of video link will not compromise on the standard and quality of the proceedings and will not affect the process of justice, and whether cybersecurity measures will be in place to ensure that the links are free from being hacked by external parties, and whether there will be consultations with stakeholders and the court users. Careful consideration has been given to ensure that the fairness of the hearing process is not affected by use of video link. We have and will continue to engage with the criminal bar and other stakeholders on the implementation of this scheme. The necessary security measures will be considered in the technical part of the planning and implementation. Ms. Sylvia Lim expressed some concerns about whether allowing video link proceedings for guilty pleas and sentencing proceedings will diminish the impact of warning from the judges. Actually, one of the reasons why we are extending video link hearings to more substantive matters at this time is improvements in technology. We will be using video link technology with sufficient audio and visual fidelity that the court proceeding will not be adversely affected. This is actually part of the overall general move. We think that going forward, technology is going to be more and more infused in practice, both civil as well as criminal. So that's the direction in which it is moving. Ms. Lim was also concerned with the confidential communication between defense counsel and their clients. We had consulted the Law Society and the criminal bar, and they too had raised this point, and we had had discussions with them. The prisons currently operates a televisit system that allows counsel to interview their clients in remand through teleconferencing without physically traveling to the prison, and that, as I understand it, is secure. The client solicitor privilege is protected. Obviously, the confidentiality is protected as well, and that has been working reasonably well. From past experience and based on our conversations with the bar, we think that there is a consensus that with the right technology and processes, we can have systems for communications that will satisfy the requirements of the defense. So in short, we'll continue to consult the criminal bar on the implementation in this respect, but the important thing will be to ensure the confidentiality and that the solicitor-client privilege is preserved. But in essence, currently there's already a system for counsel to speak to the accused and to take instructions. Dr. Tan Woo Ming asked about the kind of subsidiary legislation that we envisage for regulating expert evidence and whether there will be consultation on the proposed regulations. The answer is yes, there will be consultation with relevant stakeholders. One example of subsidiary legislation that we envisage is, as Dr. Tan already alluded to, is to expressly state the obligations of an expert witness as is currently done for civil procedure. Mr. Patrick Tay, Mr. D'Souza, and Mr. Kok Heng Leun all asked whether there are safeguards to ensure a sufficiently wide choice of psychiatrists. The selection of criteria has not been finalized yet. It's not the intention to set an extremely high bar for admission to the panel. We expect that most psychiatrists with the relevant forensic training will be able to qualify. They will be drafted to ensure that there is a sufficient pool for psychiatrists, and MinLaw welcomes any feedback as we work through on how to formulate the criteria. This should also deal with Mr. Kok's concern as to whether it will be more costly to hire psychiatrists. Given that we expect that the impact on the choice of psychiatrists to be minimal, it shouldn't become more expensive for the accused person to hire a psychiatrist. Mr. Kok expressed concern that a psychiatrist on the panel may be unwilling to state honest but controversial views. The proposal is not intended to target psychiatrists who give unconventional views. It's intended to target psychiatrists who display a clear lack of objectivity or competence. A psychiatrist will not be removed from the panel just because the court doesn't accept his or her opinion. The basic thing is objectivity and competence. We also note Mr. Tay's suggestion to provide the panel of psychiatrists with training. We will work with stakeholders to see what needs they have in this regard. And Mr. Pillay asked whether there will be a fixed quota of psychiatrists. The answer is no, no fixed quota. Mr. Murali also asked for elaboration on what other factors the selection committee will take into consideration in deciding whether to admit a psychiatrist to the panel, besides qualifications, work experience, and character references. As mentioned, the selection criteria has not been finalized, so we will work with stakeholders on suitable criteria. And if members, especially those in private practice, have thoughts on this, they should feel free to send their feedback to the Ministry of Law. Mr. Murali asked about the clarification on the policy and rationale behind making statements recorded under Section 27 of the Prevention of Corruption Act admissible in respect of non-PCA offences. Let me first clarify that the proposal is a very calibrated shift. Statements taken under Section 27 of the PCA will only be admissible as evidence in the trial of that person for any criminal offence in the following circumstances. There is no inducement, threat, or promise that would otherwise render the statement inadmissible, and the person taking the statement under Section 27 of the PCA must have believed in good faith that the interviewee was a person who had been concerned in any offence under the PCA. Under the current law, therefore, what might happen is that a person, in the course of being investigated for corruption, may reveal that he or she has also committed another offence. The CPIB will then have to go through the artificial exercise of recording another statement under the CPC. And then what happens if, in the second statement, the accused person changes his tune and decides not to reveal the fact of such an offence? Should the accused person be allowed to avoid prosecution on the procedural ground that Section 27 PCA statements cannot be admitted in prosecution for other offences? So the real concern then is whether this amendment will create an incentive for CPIB officers to circumvent the privilege against self-incrimination in the CPC. So to prevent that, we have inserted the safeguards earlier mentioned. It requires that the CPIB officer can only use the statement in the prosecution of other offences when he or she believes in good faith that the interviewee was a person who had been concerned in any offence under the PCA. Mr. Christopher D'Souza asked for a clarification on whether the change to the admissibility of Section 27 PCA statements is a clarification or a change in law. The explanatory statement uses the word clarify because the relevant court decision states that in respect of non-corruption offences, the failure to inform the person interviewed of his privilege against self-incrimination, coupled with telling him that he is legally bound to tell the truth, may amount to an inducement. So this leaves it debatable in each case whether merely telling a person that he is bound to tell the truth amounts to an inducement. And the amendment therefore clarifies that on its own, telling a person that he's legally bound to tell the truth shall not render a statement inadmissible. However, this clarification is achieved through a substantive change. Courts will not be allowed to treat the mere fact that a CPIB officer told the interviewee that he's bound to tell the truth under the Prevention of Corruption Act as grounds to find that the statement was given under an inducement for the purposes of a non-corruption offence. Community sentences. Ms. Joan Pereira asked about the uptake rate of community-based sentencing. Since 2011, the number of offenders who were sentenced to community sentences has varied from around 100 to more than 200 offenders. We will continue to work with stakeholders to encourage the use of community sentences in suitable cases. Mr. Patrick Tay asked for statistics on MTOs. Given that MTOs, along with the various other community orders, have been introduced relatively recently, we have limited data on recidivism. Having said that, early data suggests that the recidivism rate amongst offenders sentenced to community sentences tend to have a lower rate of recidivism than the general prison population. Mr. Tay also asked what safeguards are put in place to ensure that victims of offenders placed on MTOs are protected while the offender is receiving treatment in the community. And he cited the case of a woman who continued harassing her neighbor despite being on MTO. The court is unlikely to impose an MTO where there's clear evidence that the accused person is likely to cause danger to others while remaining in the community. And in such cases, the principle of prevention is likely to outweigh the principle of rehabilitation. The court may also impose conditions as it thinks fit to mitigate the risk of harm to the victim. We're also enhancing the MTO regime to allow for more flexibility of the treatment programs. For example, we're empowering the court to order a period of inpatient treatment for cases which require more intensive treatment. Ultimately, we'll have to accept that there is some risk created when imposing a community sentence, but this must be weighed against the alternative, which is likely a relatively short sentence of imprisonment. If the root causes of offending are not addressed, the offender has a high chance to reoffend upon release, especially if the cause is mental illness. Ms. Pereira asked for an indication of the kinds of more serious offences that will be described to render them eligible for MTOs. The expanded list of offences which will be eligible for MTOs under the revised criteria will be clearly set out in legislation. Offences that reflect a danger to public safety or which require greater deterrence will not be prescribed. Mr. Murali raised 2 points, which he also raised earlier in an adjournment motion on community-based sentencing. First, he observed that the court cannot take a different view from the appointed psychiatrist as regards an offender's susceptibility to treatment. He also cited a previous case that he dealt with where an apparent change in opinion on the part of the appointed psychiatrist resulted in the court being unable to impose an MTO on the accused person. Let me begin by making a brief clarification about the case that Mr. Murali refers to. We had checked on this with IMH following the adjournment motion in September last year. The psychiatrist in question explained that his first report had indicated that while a period of inpatient stay may be beneficial in his condition, the likelihood of significant improvement in his condition with treatment was very low. The report was not for the purposes of assessing MTO suitability. The second report, some 4 months later, was for the purposes of assessing MTO suitability. And in the second report, the psychiatrist concluded that the offender was in fact not suitable for MTO, as the treatment available was not likely to result in significant improvement in his condition. So I hope that this clarifies the situation that Mr. Murali raised. Mr. Murali's broader point, however, is that the court should be allowed to impose an MTO, notwithstanding the appointed psychiatrist's opinion that the offender is not suitable for MTO. The reasons for not taking up this suggestion are as follows. Given that generally IMH is the institution to administer treatment under the MTO, there's a concern of conflict of medical ethics if IMH were to be asked to treat a person it believes does not have a treatable mental condition. And the current position, therefore, aligns the diagnostic and treatment elements of MTOs. As regards Mr. Murali's point on the difference between the MTO regime and the RT regime, there is in fact no inconsistency. In the context of a RT pre-sentencing report, the psychiatrist is focused on whether there is any aspect of the offender's mental condition that renders him or her unsuitable for RT. For example, the psychiatrist will take into account whether any condition will be aggravated by the RT environment or whether it will affect his or her ability to be rehabilitated in the RT environment. If the psychiatrist does not find any reason to recommend that an offender is unsuitable for RT, and the court finds, after considering all relevant factors, that the offender should be sentenced to RT, the end result is that the offender will be sentenced to RT. The offender is not sentenced to undergo mandatory treatment for a psychiatric condition. The ethical issue highlighted above does not, therefore, arise in the context of RT pre-sentencing reports. Mr. Pillay asked for an update on the Ministry's consideration of his proposal made at an adjournment motion sometime back on moving towards a different test for determining MTO suitability. The Ministry is still studying the proposal. In the meantime, the amendments today significantly expand the range of offenders potentially eligible for MTOs, and we hope that this will go some way to addressing Mr. Murali's concerns. Mr. Louis Ng asks whether we intend to eventually allow the courts the full discretion to decide when a community sentence can be imposed. We've taken a balanced approach in deciding which offences and offenders should be eligible for community sentences. Some crimes may be too serious, and it would not serve the justice system well to allow such offenders to be given community sentences. Some offenders may not benefit from community sentences. Hence, the regime is carefully calibrated, and we need to draw the line somewhere. Nevertheless, we will continue to examine the eligibility requirements and extend the line where appropriate. Mr. Ng also asked whether we'll consider giving the courts more alternative sentencing options. He asked this in the context of a recent case where reformative training was imposed on a young, intellectually challenged offender for the sexual assault of a 16-year-old girl, and Mr. Murali made a similar observation about the limitations in that case. We've taken note of this case, and MHA will consider this in the context of a broader policy review on sentencing. Moving on now to victim compensation. Mr. Louis Ng asked for elaboration on the process of ordering victim compensation. Mr. Christopher D'Souza asked a similar clarification, whether this changes the existing principle that the court should not be required to embark on complicated investigations of fact or law when deciding on compensation orders. The key procedures and processes involved will be found in the Criminal Procedure Code rules after consultation with the relevant stakeholders by AGC and the courts. We have already been consulting these stakeholders to ensure that the processes and procedures implemented will be simple and inexpensive. Mr. Ng asked whether there would be a limit on the amount of compensation awarded. There's no statutory limit on the compensation that can be ordered. That said, compensation orders of a certain amount can only be made by the criminal courts if there is sufficient and cogent evidence to support the amount being ordered. In addition, our courts have previously said that a compensation order should not be oppressive, and the court must be satisfied that the accused either has the means available or will have the means to pay the compensation within a reasonable time. This is to ensure that the compensation order does not simply become a de facto extension of imprisonment, which may be unfair to the offender. Finally, as mentioned earlier, complex cases will have to be dealt with by the civil courts and not the criminal courts. Mr. Ng also asked about the rationale for limiting criminal compensation for a deceased victim's dependents to funeral expenses and bereavement. Criminal compensation for a deceased victim's dependents has been limited to funeral expenses and bereavement because these expenditures are easily quantified and assessed. For example, compensation for bereavement has been pegged to a fixed quantum set out in the Civil Law Act. More complex forms of damages arising from the death of a person, such as loss of amenity or loss of future earnings, should be dealt with in the civil courts. I move on now to the question of abuse of process in concluded criminal cases. Mr. Louis Ng expressed some concern about the threshold for reopening a concluded criminal case. He asked that considerations of justice and the prevention of error be given due weight even at that late stage of the proceedings, and Mr. Kok Heng Leun raised a similar concern, and I believe Associate Professor Madhav also highlighted this. The reopening procedure, including the relevant threshold test, is largely a codification of a number of considered decisions made by the Court of Appeal in balancing the interests of finality against the need to prevent a miscarriage of justice. We're confident that in administering the threshold test, which the court had itself developed in case law, the court will give due regard to the prevention of miscarriages of justice. And the government shares this concern, and that is why this procedure is being legislated. And a balance has to be struck. It may be helpful to look at the provisions of the amendments. And in terms of looking at the requirements for the exercise of the power of review, there are a few things that have to be taken into account. First, the applicant in the review application must satisfy the appellate court that there is sufficient material on which the appellate court may conclude that there has been a miscarriage of justice. So the key thing here is miscarriage of justice. And that material must satisfy the following requirements. Before the filing of the application of leave to make the review application, the material must not have been canvassed at any stage of the proceedings in a criminal matter in respect of which the earlier decision was made. So it must be remembered that this scenario is different from a scenario where something is coming up for consideration for the first time. This is intended to address a scenario where it has been heard once, there's been appeal, it's been heard, and therefore you're trying to reopen it again, which means the court has already applied its mind, and therefore the threshold is different. You therefore have to show that it is something where it could not, or it had not been canvassed at an earlier stage. Because if it had been canvassed at an earlier stage, and it was considered, and the court had said no, then really it should follow the normal procedural rules, which is that you don't reopen concluded hearings. There's also a requirement that even with reasonable diligence, the material could not have been adduced in court earlier, and obviously that is to impress upon parties that they must take all reasonable efforts to look for the relevant evidence. And the material must be compelling in that the material is reliable, substantial, powerfully probative, and capable of showing almost conclusively that there has been a miscarriage of justice in the criminal matter in respect of which the earlier decision was made. And this is repeated in other provisions where it says that the appellate court may conclude there has been a miscarriage of justice in a criminal matter if the earlier decision is demonstrably wrong and the earlier decision is tainted by fraud or breach of rules of natural justice such that the integrity of the judicial process is compromised. And it's not sufficient to show that there was a real possibility that the earlier decision is wrong. It must be apparent, based on the evidence tendered in support of the review application, that there is a powerful probability that the earlier decision is wrong. And for the purposes of the subsection on what is demonstrably wrong, it must be shown that the decision was based on a fundamental misapprehension of the law or the facts, thereby resulting in a decision that is blatantly wrong on the face of the record. In short, the underlying philosophy of this is that you've already had several chances at it, and the court has considered it, not once, but twice, or possibly a bit more. And if you want to overturn this, you must show that there's been a miscarriage of justice, or it's very, very clearly the earlier decisions were wrong. But of course, people may ask, but what if there is that one case, there's one case where actually something turns up which was not considered before, and it's demonstrably wrong, you think there's miscarriage of justice, but it doesn't meet one of these conditions. In that scenario, it is actually provided for because the amendments provide that it does not affect the inherent power of an appellate court to review on its own motion an earlier decision of the appellate court. And fundamentally, what courts seek to do is to do justice. And obviously, I would not anticipate what the courts would do, but I can say that if it's very, very clear to a court that there has been a miscarriage of justice and something is really fundamentally and really wrong, which couldn't have been addressed earlier, then the court has its inherent power to review the matter. I think I have addressed most of the queries, except possibly for one question by Professor Madhav, which is on requiring the defense to disclose a supplementary bundle, and what should be done to balance the difference in resources between the defense and the prosecution. I think the idea here is you also don't want to allow the defense to ambush the prosecution by only producing its documentary exhibits after trial, because that really doesn't save resources as well. And then it results in adjournments and the follow-up investigations, etc. And such adjournments should actually lengthen the proceedings. I think, other than that, I think I've addressed the various queries.
I believe Mr. Murali has some clarifications.
Mr. Speaker, sir, I seek a clarification in relation to the proposed Section 154A of the Evidence Amendment Bill. I wonder whether the learned Senior Minister of State as a response to my query in relation to why we're taking the secondary legislation route as opposed to the primary legislation route, especially since the broad contours of the proposal on how to protect the victim of child abuse or sexual offense from needless trauma, and how a balance will be struck with in relation to ensuring the accused's right to a fair trial is not prejudiced. It's already kind of spelled out in the Honourable Senior Minister of State's speech. Also, would it not be better for at least the broad rubrics of the policy intent to be provided in the primary legislation so that we can ensure that the rules issued thereunder would be consonant with the policy intent? And lastly, would it not be a better alternative to allow such rules to be determined by the newly proposed Criminal Procedure Rules Committee as opposed to the Minister? This will allow the judicial inputs to be obtained in the making of any such rules. Thank you.
I thank the member for his clarification, which actually extended his speech by an additional minute. Mr. Pillay sought clarification on why there is restrictions on asking certain kinds of questions of victims of sexual offences or child abuse is being contained in subsidiary legislation. The decision to place the restrictions in subsidiary legislation was made pursuant to discussions with the Law Society, as it was thought that this would allow for greater flexibility to make refinements over time to strike a fair balance between due process and preventing trauma to the victim. Mr. Murali also suggested that if the subsidiary legislation had been made in this area, it should be determined perhaps by the CPRC and not the Minister. This is so that the courts will be able to give input on the nature of the restrictions. The specific restrictions on questions have to be formulated in consideration of a very wide spectrum of interests that may go beyond the expertise of the CPRC. For example, the views of those who work closely with victims of sexual offences would be relevant. So on balance, we decided that the Minister would, for now, be best placed to consider the entire spectrum of considerations. But of course, the Minister will consult all affected parties, including the courts, when formulating these restrictions.